I want to welcome everybody to today's webinar, Legal Considerations, RIFs, and WARN Act Issues. I'm Mike Coffey, President of Imperative Information Group, and we're glad to host this webinar today with our friend Lon Williams from the law firm of Polsinelli. Lon is a longtime friend of mine and the HR community across the state of Texas, and what you really need to know about Lon is he's a really practical lawyer, which almost sounds like an oxymoron, but it's not. And he's got more slides than we could do in 2 hours. So in order that we don't waste a lot of time, I just want to welcome you. And I am here today just to be Lon's click monkey. When he says click, I'm going to do it. And so, Lon, take it away.
Hey, thank you very much. You can hear me, right, Mike?
Yes, yeah, you sound outstanding.
Excellent. Well, it's a real pleasure to be here today, particularly inside and not outside, because I'm looking out the window at the blizzard for our half-inch snowfall. Much better to be inside, warm and cozy, talking to you all about something that has been around for a long time, but I've noticed, particularly over the last 6 months, that there has been an uptick in employee layoffs, for want of a better term. Back during the immediate financial crisis, things were pretty tough, and there were a lot of reductions in force or RIFs going on. But I work primarily as an advisor and counselor, and I can tell you that on a daily basis now I'm getting requests for how do we properly conduct a reduction in force. So when Mike called me, I said this is a timely topic, so I'd be more than happy to give you the benefit in 30 minutes of, or in an hour, of what I've seen happening and what I generally advise on a general basis my clients and friends. First of all, we've got the practical RIF considerations. If you're in a position that you believe that your company is going to have to reduce the size of its workforce, there's some basic things that you need to do first off. First of all, just come up with a list of business reasons for the RIF. Sometimes, although you'd expect a company to do this, you'll get a phone call from folks higher up in the food chain who simply say, hey, we need to cut out 30 people. Well, that's nice that they made that determination, but you've got to help them from the get-go before anybody hits the road to come up with a list of business reasons that they need to reduce the workforce. Then, once you've got those reasons set aside, and they will be acting as your guideline for all this, you need to determine the order in which types of positions will be eliminated. Now, this is pretty important here, because you don't want to be put in a position of having to terminate long-time employees when perhaps you've got a lot of independent contractors out there, or you've got temporary workers from an agency, or you've got part-time workers. Most companies will want to protect, as far as they can, their full-time employees. So, first of all, you need to determine the order of the positions that will be eliminated. So, just take care of that. Typically, my folks start off with contractors, then they go to temp workers, then they go to part-time, and finally for full-time employees. Also, let me just put on something before I utter the magic word click, and that is that when you're doing a reduction in force, we talk about job elimination. That's a loaded term. When I say job elimination or position elimination, I mean the position itself is gone. For example, we don't need any more mechanics at our office or at our facility. Therefore, we are eliminating all mechanics in that job position, whether we have 50 of them or whether we have 2 of them. All are gone. After today's date, there will be no more mechanics. So the entire position is eliminated. Put that up against the other way that a workforce is reduced, and that is you say, we don't need 5 mechanics, we only need 2. Therefore, we're going to have to come up with some criteria on how we're going to determine which of those 2 get to stay and which of the 3 are being shown the door. It's a lot easier, and you reduce your legal risk substantially if you are able to eliminate a position, because there's no, generally speaking, there's no problem with totally eliminating a position forevermore. Okay, click. Mike? Oh, there we go. You're doing well, Mike. Then, once that you've sort of come up with your game plan and you're in a position of, well, we've eliminated all the positions we can eliminate, we've shown the door to independent contractors and everybody that we can, we're in a position of trying to establish some criteria for the jobs that are left, where we would want to reduce the number of individual employees in those job positions. There are a lot of objective selection criteria that you can come up with. Some people start off with seniority and length of service, and they say, well, we want to eliminate on a basis of who's been here the least amount of time. We've got 5 people. One's worked for us for a year. The guy or gal at the top has worked for us for 10 years. We want to eliminate on the basis of seniority. That's easy to do. There's no problem with it. So long as you start at the bottom. I wouldn't start off by saying we're going to eliminate all the folks with the most tenure, but you're going to start at the bottom and use that. The problem with that criteria is quite clear, and that is you may find yourself left with employees who really are not necessarily the best employees. So what are you going to do about it? Rather than use seniority or length of service, the criteria that is typically used, and I suggest, is that start off on performance evaluations. I'm sure you all have your own personal lawyers and your own personal HR consultant, and you have been to all the seminars that say you really need to have documentation as to how employees are doing. Annual performance evaluations are the foundation for, among other things, potential reductions in force. Do you have to go back 10 years on performance evaluations? No, but I'd say somewhere, and you would want to write this down as part of your criteria, you would examine performance evaluations for the prior 3 years for everybody. Okay? Then what you might do after you've put down, and this is where those numbers come in handy, you could average the overall rating for the last 3 years, or you could take the high one or the low one over the last 3 years, or show some sort of trend line performance evaluations. But maybe it doesn't help you that much because your managers and supervisors out there didn't get the memo that you're supposed to have candid and frank performance evaluations, and everybody's rated as outstanding and as having a 5 or a 5+. So what are you going to do? Well, then you go to the second phase. That is, let's see who has in their file disciplinary actions, whether they be oral disciplinary actions through progressive counseling, or written, or final written, or whatever along those lines. You look at the disciplinary actions, and you would start ranking people based upon that. The folks who don't have any disciplinary actions, they get to stay, or at least they're at the in the stay pile. Those who've had 1, 2, 3, 4, or 5, depending upon the number, would be the ones that would be more likely to be selected for separation. Then, of course, the worst case is you don't have any of those evaluations. You don't have any disciplinary actions. You're left with nothing except what the supervisor tells you, like, we got to keep these 3 people, or we got to keep these 4 people. Your goal would be to tell that supervisor, rank these individuals that you have, and the ranking doesn't say who is going to be terminated. It simply would say on a person-by-person basis within a particular job category, this is why this is the most important person we have, because this person has extra experience, they have a good reputation in the community, our major client loves this person, things of that nature that would then be set in writing so that it will give you a foundation in the absence of anything else to select who goes and who stays. It's an acceptable way to do it, but anytime you have an individual making a subjective judgment at the time of a reduction in force, it's always going to be subject to scrutiny. And don't forget, and that's fine that you click this, Mike. Don't forget that all these reductions in force, particularly after you're starting to differentiate between who's going to stay and who's going to go, is all going to be subject to Title VII under most circumstances, the Age Act, and also the Americans with Disabilities Act. Then, after you've done your rankings and got everything together, I always recommend to my clients that you set up a RIF committee. Why do you do that? Just to make sure that there's consistency and fairness in the process. You're not really relying in isolation on the supervisor out in the warehouse or the manager who happens to be in the office or whatever. You've got a second set of eyes that are overlooking everything that has been done, just to make certain that you are being consistent amongst people and that it appears to be fair. And one last bullet point there is make sure that those committee members are diverse in terms of ethnicity, age, gender, etc. You don't want, in fact, I just went through this relatively recently for the committee with just a bunch of white folks, and unfortunately, a lot of the folks who are being shown the door were people of color. That it all may be perfectly legitimate, but it at least raises the scrutiny of perhaps the EEOC or the Fort Worth Human Relations Commission or the OFCCP, the Office of Federal Contract Compliance. And there's no reason to paint yourself into that corner. Okay, next. Other determinations. This is an early on decision that you need to make. Whether employees are going to be allowed to transfer to other positions and whether there's going to be any replacement going on. It always comes out when there's a reduction in force that somebody will say, well, wait a minute, I've been here for 10 years. And let's say you're not using seniority, but you're using performance and all that stuff. And you've come up with somebody that is going to be moved from his or her particular job category, and they say, well, wait a minute, I've been here all these years. Can I transfer to another position for which I'm qualified? You don't have to allow them to do that. But if you do allow them to do that, you're going to have to be consistent with it. A lot of times, you don't want to allow people to transfer. But you need to make your own decision on that. There's no obligation that you allow somebody to transfer. Okay, next. Initially, with a reduction in force, the issue is, are people being treated consistently for purposes of treatment? In other words, are you treating one person differently because of their age? Or are you treating another person a little bit differently and inconsistently because of their disability or because of their gender? Remember, under Title VII particularly, and also under the Age Act, and to a certain extent under the Americans with Disabilities Act, you could still be liable for disparate impact. In other words, the decisions that you're making, when looked at in whole, would appear to show that you are trying to show the door to all people or to people over the age of 40 in a statistically higher number than those under 40. How do you even know about that? Well, this isn't going to apply to the smaller employers, but certainly you got to have 15 to have Title VII and those other laws apply to you. But let's assume you're a mid-sized employer with 25 employees. You're not going to have a whole lot of extra money lying around. But let's assume that you've got a nice-sized workforce, maybe somewhere north of 100 employees. I suggest that you get a statistician to run an analysis on adverse impact for particular protected categories, such as age, such as race, such as gender. Those are the three biggies. And before anybody is shown the door, before you put the stamp of approval on this reduction in force, you will have had your statistician run the numbers just to see whether any protected category of those three is being adversely impacted by your decisions. Okay? Now, having said that, let's talk a little bit about the WARN Act. And the WARN Act is the Worker Adjustment Retraining Notification Act, which has this clever acronym of WARN. I can just see some of our folks working in Washington spending untold hours trying to come up with an interesting acronym for this. So they came up with WARN Act, and that is what it is. In the case of a reduction in force that we'll talk about in a second, you have to give notice to your employees who are being shown the door. Now, if you're an employer and you don't have 100 or more employees, excluding part-time, unless the part-timers work more than 4,000 hours in a work week, the Act does not apply to you. Like I said, there are a lot of reductions in force going on right now, and almost every one of them, after they seek my advice on how to organize the reduction in force, they say, hey, I've heard a little bit about that WARN Act. Do you think that that applies here? The first words out of my mouth, how many employees do you have again? And if they've got 90 employees, no, the Act doesn't, so don't worry about it. However, let's assume that you as an employer have more than 100 employees, then the Act is likely, most of the time, to at least apply to you. So what would trigger your obligations under the WARN Act if you've got more than 100 employees? There are only two instances. Number one is in the instance of a plant closing. That can also be a department closing where the entire facility or the subdivision or the department, like accounts payable, is being shut down. Then that would be a plant closing, or there could be a mass layoff. Let's talk about some of the specifics of each of those under the WARN Act. If there's a plant closing, it is a permanent or temporary shutdown of a single site of employment. Keep that in mind. There's a reason that on the slides it's in bold and underlined. It's only the single site of employment where this department is being shut down. If you've got operations across the country, that isn't going to cut it. That doesn't count as a single site of employment. Or, and we also talked right here in the second bullet point about various facilities or operating units within a single site of employment. Let me just say this. The Fifth Circuit, which is the Federal Circuit Court of Appeals, which is responsible for state federal court decisions, including, among others, Texas, they have come up with three factors that determine whether it is a single site of employment, a single site of employment. Here are the three factors. They are not on this slide because I wanted to have something to talk about. And that is, a single site sites must be geographically proximate to each other. Does that mean you've got 4 buildings on your campus and all are separated by about 20 yards? Does that mean that only what happens in one of those buildings is a single site? No, they could be in reasonable proximity, geographic proximity to each other. There's some cases out there that say, well, yeah, you had another facility right across the street. I mean, so you're talking about 50 yards across a busy highway, maybe across the interstate. It's been held in some cases that, depending upon circumstances, that is a separate site for purposes of a WARN Act, plant closing. The second factor is, do the other single sites serve the same purpose or function? Maybe maybe you are looking at folks who are in one side of the freeway and in one building, and in the other building is a different division or a different function. Maybe you're looking at administrative offices in one building, but the other building is only operational people. That they would not have, it could be argued, they would not have the same purpose or function. So that test, that number 2, may not be met, and therefore the WARN Act wouldn't apply because they're not part of the single site of employment. And finally, the sites must share staff and equipment. I've had a couple lately where they really do have separate staff. They have a separate HR department or separate HR person, and they have a separate computer system. That would cause that single site not to be a single site. And don't forget, the Fifth Circuit says that all these 3 factors, geographic proximity, same purpose, and same staff and equipment, must be met in order to have a single site. Okay? This slide is a little bit out of place, but I didn't know where else to put it. And that is that the WARN Act really doesn't treat a sale of a business as an employment loss, generally speaking. So that would, and why it would be an employment loss here is it a plant closing if you sold your whole operation to somebody else? You've got to be careful of it in these documents, in the purchase and sale agreement, whether it's, particularly if it's an asset transaction. But if you've got typically stating, just because you're selling the assets and the people are being terminated on your side doesn't necessarily mean that this is going to be an employment loss. Particularly if you put in there that all of your employees are going to be offered employment at the entity that purchased all your assets. So it's not a deal killer here. You need to pay attention to it, and you need to talk to your lawyers to make sure you're papered up. But just be careful on that. But don't be unnecessarily concerned about it. Now, in addition to the plant closings, you might have something called a mass layoff. And this is what you really see more of these days. And that is a reduction in force that's not a plant closing. Okay, we've already established that. And the results in an employment loss at a single site of employment during any 30-day period, or, click, at least 33% of the active employees, except for excluding part-time employees. And you've got to have at least 50. So let's say you are going to have a layoff across all sorts of departmental lines, etc. You're already obligated under the law if you've got more than 100 people to look at this. And now what you look at, is it going to be at least 33% of your active employees and at least 50 employees? Note that word and. It's not or, it's at least 50 employees. So no matter what you got going on, if you're not going to reduce 50 employees, if you're going to only hit 45 of your workforce, then it is not going to be covered under the WARN Act. And that, as we'll talk about here in a moment, is during a 30-day period. Now, excluded employees. Folks who may be excluded from the employment loss category are employees terminated because of misconduct. So if you're trying to tabulate who, click, if you're trying to tabulate who in the workforce is going to be glommed into this calculation to see if you hit the 50 or see if you hit the 1/3, you wouldn't count people in there who you have just terminated because you caught them stealing. That doesn't go towards the termination total, so you don't have to worry about that. Or it doesn't have to be stealing. It could be legitimately terminated for misconduct, drunk and disorderly, inability to be at work on time, and they've been properly warned. You're going to have to properly discipline. You're going to have to prove that you may have to prove that it's misconduct. So just use your usual best practices before terminating somebody for misconduct or cause. Or employees who quit. They just said, I can't stand it anymore. The anxiety is too much for me. I quit. I've got another job. Good. They told you that, and their separation is not counted towards the total of all the employees. And certain part-timers. And then next, if you offer before the layoff transfers to other locations, unless you say, hey, we're going to transfer you to Omaha, and if not, you're probably going to be terminated. That's not good. But if you offer somebody the opportunity to transfer to Omaha, and you've not really had any discussions or any threats to them, and they want to transfer, great. They don't count in the calculation. And also, employees who are separated outside of the rolling 90-day period, that we're going to talk about in a minute, also are not included in the calculation requirement. Now let's look at a couple of little definitions here. Who are part-timers? Part-timers are quite the subject these days, particularly with the Affordable Care Act. But for purposes of the WARN Act, as of now, it could change tomorrow with the issuance of new regulations or governmental edicts, employees who work fewer than 20 hours per week, or employees who have been employed for less than 6 of the last 12 months preceding the date on which the WARN notice is required. So those people would be excluded. Employment loss under these definitions means termination other than cause, voluntary departure, or retirement. We didn't mention retirement, but if you have some people who just decide, hey, I'm hanging them up, they're not counted in this group for employment loss purposes. Okay, let's go to the next one to stay on time here. And an employee has not suffered an employment loss if they are allowed to transfer. Got that covered. Now, click. A facility is a building or group of buildings. That is clearly important when we're trying to determine single site of employment. An operating unit is something that's organizationally distinct and crosses within or across facility lines at a single site of employment. That's good to know. And then the definition, just to cover this finally, is single site of employment can either be a single location or a group of contiguous locations. Had an operation here about a year or so ago with similar facilities in Fort Worth and in Dallas. That's 30 miles. And it was determined that that was not, even though they met 2 of those tests, they were not geographically proximate to each other. So it was not a single site. Now, you've got all this stuff. When must notice be given under the WARN Act? You've got to give it, assuming you met all those criteria, you've got to give notice to the employees, first of all, at least 60 calendar days prior to the plant closing or the mass layoff. In other words, 2 months. Now, before, go back if you will, Mike. 2 things to keep in mind here. That would reduce this 60 calendar day requirement. And what would reduce that 60 calendar days? There are 2 things. Number one, you could have a faltering or a failing business where you're out there, things are heading south financially for you all, and you're trying to get it refinanced to keep the doors open so you don't have to go Chapter 7 or Chapter 11 or just wander off into the woods. And if you were to give the 60 days notice because you're out there looking for financing, that would be the last nail in the coffin, and the any hope of financing if all of a sudden they see in the potential financial sources in the newspaper that you're given 60 days notice to your employees, that'd be a death knell. So under those circumstances with a faltering business, that would reduce the 60-day period. That doesn't mean you don't have to do it. That just means, let's say you're starting the process, you're working really hard, the last bank or or rich person standing has decided, nope, I'm not going to put my money into your company, and you decide that everybody needs to go 10 days later. Well, that's when you have reasonable time to tell your employees, we're shutting it down in 10 days, or we're shutting it down in 2 days, or we're shutting it down tomorrow. And it's got to be in some pretty close proximity to when you get that notice from the golden treasury person that they are not going to help you out. The other reduction in the 60-day period, I'm seeing this more often than not these days, is the unforeseeable business circumstance. What would that be? That would be the loss of a contract. Like things are sort of going bad in certain industries right now, and you're hearing via the grapevine from contract holders saying, you know, I don't think we can keep on using you guys. But they've not told you they're going to cancel the contract. They're just saying they're thinking about canceling it. Thinking about canceling it doesn't count. But once they say, I hereby cancel this contract, then that would allow you to reduce the 60 calendar days of notice. Because if there is no more work there because they canceled it, then that's all she wrote. And you can only give notice that you really have. Okay. Next, notice determination. And this is where it gets a little bit sticky, and I think there is a lot of room for confusion because, frankly, I get confused about it, and I keep a copy of the WARN Act next to me when it gets into the 30-day period or the 90-day period. So we've determined that you're going to have to give 60 days notice. You're calculating whether you hit the 50 or whether you hit the 1/3 or whatever. You look ahead 30 days and behind 30 days to determine whether the employment actions will total for any 30-day period the minimum numbers. So if you're looking ahead 30 days, looking backwards 30 days. In other words, what you have here is a rolling 30-day period. Now next, this is the confusion. You also, at the same time, have a rolling 90-day period to determine whether these employment actions, in other words, the terminations, are triggering the WARN Act. How could that be? Well, maybe you've done the 30-day window, you calculated that, and it comes up to be about 40 people. Great, no problem there. You don't meet the thresholds for the WARN Act. But, gosh, 3 weeks later, you have to lay off some more folks, maybe 5 folks. Well, under this 90-day provision, the 40 people that you laid off, but didn't trigger WARN. Now you got another 5 that certainly doesn't trigger WARN. But you add those two together, you got 45. If within that 90-day period you go beyond 50, then WARN is triggered, and that's why this provision is in there. It's really there. Now you're thinking, well, you know, I only am laying off people when I absolutely positively have to. The government doesn't trust you. I know you're doing it in a nice way, and you don't want to terminate people unless you have to. But there are folks out there, there are employers out there who, seeing that rolling 30-day period, will make new decisions every 31 days that fall right under the threshold. Perhaps during one 30-day period, they eliminate 49. The next 30-day period, they eliminate 49. And the third period, they eliminate 49. None of those would trigger WARN Act. But it is possible that some employers would take such action purely to avoid WARN, and this provision, this regulation, stops those people from doing it. Okay? And when does the termination really commence here under the WARN Act? Because sometimes employees are not terminated on the same day. The date of the first individual termination within the 30 or 90-day period is when the actual termination calculation starts. Although I will tell you there are some court cases out there that argue with that, but this, as a general rule, is the case. Now, who gets the notice? The notice certainly has to go to employees who are affected. So you've got to send notice to the people who are being separated from employment, including any part-time employees, even though they weren't in the calculation for reaching the threshold. But you've got to send your notice to all employees who are going to experience that employment loss. Who else do you send the notice that 60 days, or could be more than 60 days, 65 days from now you will be separated? Tell the employee that, but who else do you have to tell? You have to tell the state dislocated worker unit. And here in Texas, that's the Texas Workforce Commission, and they actually have a unit called the Dislocated Worker Unit. So it's really easy. You can get on their website and you can find out where to send that particular notice. And then last, in terms of entities, individuals who need to receive a notice, is the chief elected official of the unit of local government in which the layoff will occur. That can either be a county commissioner or a city manager. You know, and if you're in Tarrant County, why just send it to Hearst, Euless, Bedford, the mayor? You also, I think, to just cover your bases and to reduce risk, also send a copy to one of the county commissioners. Now, what's contained in these notices? They got to be, particularly the ones to the employees, they got to be written. You can't just get on the loudspeaker and tell them across the plant floor. It's got to be written, it's got to be specific, and in a language understandable to the employees. Well, that's sort of loaded, and language understandable to the employees. If you have a large number of Hispanic employees who only speak Spanish, I would put it in English and in Spanish, and I'd also put it in language that is non-legalese. My colleagues, as I'm sure Michael and you will probably agree, lawyers talking their own lawyer speak. This needs to be in verbiage that any employee can understand that they are getting ready to be separated and you're giving them 60 days notice. Within that notice, those employees, it's got to tell them whether it's permanent or temporary. It's got to tell them whether it's the whole plant that's going to be closed or whether it's just going to be a department. You got to give them the date when this is going to occur, generally speaking, and a date when it's going to, generally speaking, affect them personally. In this notice, you got to tell them whether there are any bumping rights. Bumping rights, and you might click that, Mike. Bumping rights are when, okay, I am being separated, but I've got the right to bump a less experienced person in my job group. That's something. That decision gets into seniority and all sorts of stuff. But in this notice, you're going to have to put in there that bumping rights either exist or they do not exist. And then finally, the name and telephone number of the company spokesperson for this. How about the notice to the state and local unit of government? Very similar to what we discussed to employees. You've got to put the name and address of the employment site where this is going to occur, the name and telephone number of the company spokesperson, when, whether it's expected to be permanent or temporary. Okay, click. When the first separation is going to likely to take place, and anticipated, reasonably anticipated schedule for future separations. Job titles of people who are going to be affected and the number of affected employees in each job classification. And also, since you're talking to either the state or the local unit, you're going to let them know whether they're bumping rights, because they need to know that, because they will put out their own press release on it. Now, next, remember this is 60 days. You got to give them 60 days notice. Well, what if you can't give 60 days notice? Well then, generally speaking, you're going to be responsible for the financial gap between the notice that the individual employee has and the 60-day period. So forget we're not talking about faltering business or unforeseen business circumstances here. We're just talking about because of your hierarchy and the folks higher up in the food chain, they say these folks need to be gone within 10 days. Well, that leaves you about 50 days short. So you're giving them 10 days notice, but for the other 50 days, you're going to have to pay them their pay for that 50-day period. However, if you've done your homework and this is not a surprise to you that this is coming down the road, you could have a severance pay plan in there that would allow you to reduce the amount of that 60 days. Right here it says that you can give them pay in lieu of notice, and it can be reduced by any voluntary and unconditional payment by the employer to the employee, that it's not required as any sort of legal obligation. If you have a severance plan out there that says when you're laid off, you are entitled as one of our employees to 30 days of separation pay. That isn't going to allow you really to reduce the 60-day payment, because there's a legal obligation there that you pay them that amount of money. However, if you've got a plan, a sort of a super severance plan that says that we will give you up to blank dollars of severance provided you sign a release, then that is the sort of thing that will not that will allow you to not to have to pay the gap in the 60 days. Okay, next. What happens? Forget the 60-day period here. What happens if you just don't get the penalties? What penalties are out there if you fail to give notice to the governmental agencies? Well, the good news is if you fail to give notice to the Texas Workforce Commission, there is no penalty. If you fail to give notice to the local government, there's a $500 a day fine for each day that notice is not given. So that's pretty stout. And under the law here, what they're trying to do is they're trying to make certain that the governmental entity that is closest to where you are is giving the notice that is required. Now, I notice that we've got about a little over 15 minutes left. Let's just talk a little bit about the Older Workers Benefit Protection Act. This is different from the WARN Act. This is where you maybe have an exit program for 2 or more employees. And some of you all are familiar with this, but I want to go over it because there's a lot of confusion about it. Under the Older Workers Benefit Protection Act, the OWPPA, if you're going to not just let one person go, but 2 or more people, and they're over 40, you can get them to release their claims, and they get special severance benefits. Okay, next, Michael. What sort of release of claims is it? It would be a release that's in writing. We're talking about people over the age of 40. And it's in plain language. Once again, it's got to be language that is understandable to the individual at their comprehension and educational level. And it can't be misleading or anything. Next. In this release, and I do a lot of them, whether there's a RIF going on or whether there's just a general separation of employment, even a termination sometimes for cause or for misconduct, if you want to make certain that the person isn't going to come sue you and they're over 40, you probably need to go through these steps as well. And that is that when you have a release of any claims, you have to specifically reference the Age Discrimination and Employment Act. If you just have a simple, I release the company from any, in exchange for this money, I release the company from any and all claims I may have under any employment laws, that will not cut it for those folks over 40. You've got to say, including the Age Discrimination and Employment Act. And you have to make certain that that release that you have right there states on it that this only releases any claims that the individual has as of the date they execute it. Usually that is found in the first sentence or so. Okay, Mike? Time periods. Biggie, biggie, biggie. If they're over 40, you got to give them 21 days, generally speaking, to allow them to release you from any age claims they may have. I have been brought into separation situations a lot where the client will have their customary release that's been drawn up for everybody by their lawyer, and I'm sure it's good, but some of you guys, when you get something from a lawyer, you go, great, I don't ever have to get that from him or her again. Bad practice, because what will happen is that this will be an age release that'll say, and you got 21 days to talk about it, but unfortunately, you've just given it to somebody who is under the age of 40. That says two things to the other side. It says you guys don't know what you're talking about, because if they're under 40, all you have to do is give them a reasonable period of time to think about it. That's all. But if they're over 40, you've got to give them 21 days. If it is a group of employees who are over 40, you give them 45 days. So look at those templates that you have from your lawyers. And if some of them say 21 days, some of them say 45 days, the 45 days relates to what we're talking about today, and that is the reduction in force, where numerous people, more than one person, is being separated from employment. And it's just, I think it's just so critical that you pay that sort of attention to these releases. Get your time straight. Now, let's say, as a prelude for this particular slide, so you can keep it here, Mike. I think if you have 21 days or 45 days, the employee, best of all possible worlds, says, thank you, thank you, thank you. I'll sign it right now. That's a good thing, depending upon the language of it, but I don't want to wait the 21 days. I don't want to wait the 45 days. As long as you're not twisting their arms, they may sign it the second that you give it to them. However, they're over 40, they also have 7 days to revoke that signature, because as we all know, Michael particularly, once you hit the age of 40, you are immediately, for purposes of law, become incompetent and incapable of making any sort of immediate decision. So if you're over 40 and you're trying to get a release, then thank goodness you got 7 days to change your mind. That 7 days cannot be waived. So the person will say, hey, I'm signing it right now. Can I get my money tomorrow? The answer is no. You cannot get your money until that 7-day period has gone by. Now, special requirements for group reductions. And this is important, and I want you guys to know it when you see it. Let's say you've got a group, a reduction in force. You've got folks who are over the age of 40. You have to provide, pretty much as an exhibit to the release, a sort of a little exhibit that indicates, for those over 40, the class, unit, or group of individuals covered by this severance plan, any eligibility factors for the program, and any time limits applicable to such a program. In other words, the 21 days, the 40, or actually it wouldn't be 21, it'd be 45 days. This is an actual written exhibit that typically is attached to the release or the waiver. What else? What needs to be on there? You need to put down job titles and ages of all individuals eligible or selected for the program, and the ages of all individuals in the same job classification who are not eligible. So what you would have is you'd have a narrative saying this is part of the spring reduction in force of the ABC company, and people who are affected by this have 45 days to think it over if they want to accept our offer of separation, or words to that effect. Then down below that, you're going to have a little spreadsheet or a little chart, and it's going to have several columns in it. One column is going to be job title, not people, but actual job title. Then the next column is going to have the ages of all individuals who are eligible or selected for the program, and then another column of ages of all individuals who, in that same unit or classification, that are not eligible. So you just have eligible yes column, 40 years of age, or 42 years of age, not eligible, 22 years of age for each job category. Sometimes, and this is where I get pushback because people say, well, you know, that will cover, that'll be about 10 pages. The answer to that is it may. So, and you'll get a lot of pushback from your folks to whom you report. Now, next one, and we're getting near the end here, is that one of the things that we can talk about, if this, or you should mention to your counsel, is the decisional unit. Does this cover the decisional unit in terms of who gets the severance plan, who's eligible for it, who's not eligible for it? The decisional unit is typically every department that was considered under this specific reduction in force. For example, if the president brought in the 3 vice presidents on December 1st and said, ladies and gentlemen, I want each of you to come up with a plan to reduce your employee workforce, then the decisional unit is the whole doggone company. On the other hand, if the president or your vice president comes into you and says, we need to, we've decided that we really don't need all those folks in accounts payable, therefore I want you to come up with who's going to stay and who's going to go in order to get this severance, then the decisional unit for that purpose would only be the accounts payable department. And it just has to be given to the folks who are 40 or older in that decisional unit that you're going to try and get to sign the release of the waiver. So we've got 7 or 8 minutes, and I'm ready for any questions. And if I don't have the answer to the question, because this is a moving target, just let me know how to get in touch with you. You can email me or call me at this number right here, and I'll try to get you an answer pretty doggone quick. Just in case I can't get home tonight, I may be here all evening. So,
let's hope not.
I got going.
Okay, well, right now we've got one question. Everybody, you can drop down to the question box and drop any questions that you might have for Lon into that question box. And we'll start with this one from Susan. What would be the benefits or risks of allowing or not allowing employees to transfer into other roles in the event of a RIF?
I think that the risk there, and you have to make that decision to transfer really for the entirety of that RIF. And what I'm working on right now, the reduction in force is because there are a number of people who simply are not performing. And in that particular instance, if you allow the folks who are going to be targeted by the RIF to transfer, then you're just moving one problem from one department into another problem, and you may be getting rid of some really pretty good people that you'd otherwise want to keep. It's almost the same sort of issue that you go through when you set your, if you were to set your criteria as, well, we're just going to make this simple. We're going to make it by seniority. Last in, first out. So it's that sort of analysis.
Let me ask a question that a lot of our clients are oil and gas, and with the low price of oil, you know, a number of them have had to let people go. But in those situations where you've got people in terminals, you know, maybe there's, you know, 25 employees out in this terminal in this drill location, and then, you know, 50 or 60 miles away, there's another, you know, 25 or 30. But in none of these locations do they have, let's say, you know, 50 employees and they don't, so would those be distinct work sites then? Or, and of course everything is still situational, but.
Right, that is such a good question because there's a lot of that happening right now. And here's the situation that I've observed in many instances in the oil and gas business. When you've got a bunch of work sites out there, the people who work on those work sites, they start off each morning in the yard, and then they are transported to the work site. Maybe it's 10 miles away, maybe it's 20 miles away. And in those instances, it's the yard that counts.
Oh. So where they start their day or that common area. Okay. Wherever the boss sits.
That's right.
Okay.
And if you were, though, you got housing units sitting out on a work site, that's a little different. Now, we're not talking about you sleep out there for a day or they've got a bunk room there. We're talking about where they are commuting out there. And the single site is really going to be the yard.
Okay.
However, you raise a good point, and that is it's going to be case-by-case basis. So there could be a lot of factors out there that could make some of those individual work sites, depending upon where folks are sleeping and the circumstances of that work site, as a single site that would not meet typically the 50 threshold.
Well, let's get into the warm and fuzzy part of it real quick. You and I have both been in and around HR for a long time and seen ups and downs. And, depending on who you talk to, everybody's got an opinion about when do you tell your employees about it. Is it better to do it on a Friday afternoon or as soon as you know, some people say let them know during the week so they can start taking action so they're not fuming all weekend. Other people say wait till the end of the day on Friday. What's your opinion on the best timing of making that notice, assuming that, the creditors aren't going to come lock the doors tomorrow?
Right. I'm a real strong believer in doing it earlier in the week than later. I like Mondays and Tuesdays.
I do too. Yeah, good.
Because the reason is that if you do it on a Thursday or, goodness, on a Friday, then that person is going to go home and they can't do anything about their situation except sit there on the couch, get madder and madder, perhaps with encouragement from a spouse or a significant other and a six-pack. And by the time Monday comes, they're going to be very, very angry. I really prefer Monday or Tuesday at the latest on a Wednesday.
There you go. Yeah, I've always felt like that. If you could do it early in the week and get them directed towards a next step. I mean, one of the best things I think a company can do, and there are a lot of relatively inexpensive options for doing it now, is doing some sort of career counseling, job search assistance, anything like that, even if it's something, with workbooks and, a website, things like that. They're out there and they're relatively inexpensive. Just giving somebody something to start working on and help them build a path, a plan is gigantic.
Right.
What about having that conversation? How much, when we're terminating somebody for cause, we always say, don't get into extraneous things, just lay out the facts and allow them to exit as quickly as possible. How would you handle something, like this where it's not for cause and whoever's delivering the message is probably feeling a lot more compassion for the individual than they may if they're throwing the bum out.
Well, that's correct. I think that the most important thing that you can do is not to unnecessarily make this person, let me back up. If it's a not-for-cause reduction in force, the tendency for many of us soft-hearted people, including this particular lawyer, is you want to say, I'm sorry, I apologize for having to do this. that's not a good thing to say, because it implies that somebody is forcing you to take this action against this person, and those sorts of words can be and will be used against you if the person goes out and gets a lawyer. So what you have to do, I think is very important, is to lay out just briefly in the oral presentation, we have had to reach a business decision here, which requires that we reduce our expenses, including some of our workforce. But you've decided to implement a plan to assist you, because we like you and all of your other workers, to allow you to at least have something to allow you to transit into your next place of employment. And what are we going to do? We've got this severance program. Of course, you got to sign a release, but we think it's reasonable. And we're also going to provide you with outplacement. And we're also going to, I'm seeing more and more of this, we also are going to pay a certain amount of your health care under COBRA for a certain period of time. You know, COBRA, you got 18 months, you might say, and furthermore, we will pay your COBRA premium to you for a 2-month period. What you're doing is you are telling those people that they have been of value to you. You're not just giving them the heave-ho out the door, but you are making this decision not based upon anything other than the fact that this is a business decision that we need to reduce some of our expenses, and employment expense or employee expense is one of the components of that.
What about the dreaded question, well, will y'all give me a good reference?
Yeah. I think these days, Mike, you gotta go with the neutral reference. And in these days, the reason I say these days, in the old days, if you gave a future employer a neutral reference on an employee, they would immediately think, aha, there must be something out there. However, fortunately, there's been so much in terms of seminars and webinars like this that everybody knows that the preferred method of operation is simply to give a neutral reference, which is the name of the person, their job position, their job responsibilities, and their tenure. If the person will sign a statement saying you can tell any future reference my wage or compensation history, but you got to have something signed for that, then that's fine too. Now, so I think that is a perfectly acceptable way to do it. Sometimes in a reduction in force, you can put a little clause in there that says, and furthermore, the reason for this person's separation related to our spring 2004 reduction in our workforce. That sends a real message that, you know, it wasn't for misconduct, it wasn't for poor job performance. This person just got caught at the short end of the stick.
Now, delivering the notice, you may have seen in the media there was. I'm sorry. Go ahead.
What I'm talking about right here, I'm talking about this terminating people. I'm not talking about the WARN Act.
No, right. Right, just how you know, when the time comes and you've got to sit down with people. You know, we've seen some of the high-tech companies a couple years ago sent out mass emails to all the people that were being laid off saying, you know, clean out your desk, you're done. And I don't think that's, they got a lot of blowback from that, and I think that
is not good.
Yeah. I mean, the PR war continues long after the person's gone. It's our mutual friend Brad Smith taught me years ago when I was in my 20s and I had to handle well, not my first, but a layoff in healthcare environment, and Brad was one of our consultants, and he said, Michael, the people will not remember a word you say today, but they will remember how you make them feel. And that was true, and I've carried that lesson with me. If you can treat people with dignity and respect through this process, show them that the company is has done the company's best by them in this process, and make them feel like they've been they were valuable to the company, and the company's just in a different situation now.
Sure.
That will mean so much more than letting them leave angry or with unanswered questions, or that belief that there's some other reason they're getting rid of me. I think that's the worst thing you can do, is have them leave thinking, well, that doesn't make sense. Why? I don't understand why it was me that left, because then they're gonna go straight to protected class issues, and they're going to believe it was something other than the actual reason you selected them. So it's really important to be really frank with them. What do you say about sharing with them how the selected, how much would you share about how the selected pool that's being laid off was selected?
I wouldn't tell them in writing,
Mm-hmm.
but what I would say is that we tried to use some objective criteria, such as performance evaluations, disciplinary notices, things of that nature, in coming up with this ranking. And then they say, well, I've had good performance evaluations. And the answer to that question is, we know you have. You're not being terminated because you're bad. You're being terminated. You're being separated. That's a better word to use in this context. You're being separated because we had to reduce the number of people in this position. And although you are way above average, you maybe are at the good level or the good plus level, there were people who had higher performance evaluations than you did in your job. So if we weren't doing this reduction in force, you wouldn't be terminated because you're a good employee.
Yeah, in other words, if you were working for a lousy organization with a whole bunch of subpar performers, you wouldn't be out of work today.
That's correct. Or we've got you ranked, over the last several years as being a good one. But, there's some average employees out there, and those are the ones
mm-hmm.
that are also being let go.
Greg asked, who do you prefer delivers the actual termination message? He said that every place he's worked, it's been the business unit leader who delivers the overall message, and then HR takes over to talk about options and benefits, things like that.
I think that's a good way to do it. I wouldn't have a lead out on the floor do it.
Yeah, that frontline supervisor's not prepared to do it.
Yeah, I don't think I'd have that person do it. But I would certainly have maybe the floor manager, if it's an operational thing, do it, and then leave the room to the HR person to actually talk about the nits and the gnats of it.
Great.
But I would script out what that manager is going to be saying. And
yeah.
It shouldn't be more than about 4 or 5 sentences.
Yeah.
And make sure that manager sticks to the script.
Yeah, they get diarrhea of the mouth sometimes and keep talking and you can't stop and
That's right.
Start digging their own hole. That's true. Well,
I actually set as a little fly on the wall once for a major corporation where they let the folks know that they had completed their analysis. This was a large group. They had completed their analysis of the reduction in force, and the doggone vice president of the company said, and after we deliver the message tomorrow morning, this company is going to be a lot younger than it was today.
Oh, no.
He got completely off script and said that. I'm sitting there as the lawyer, and I'm ready to run for the door. You got to watch those folks because they'll liable to say anything. You got to have it scripted out. Now, here's the other thing. Let me say this before it sounds like you're going to wrap up, but just in terms of another anecdote. I like telling people individually that they are being let go, just like we've talked about right here, and then bring together everybody who's left, rather than the reverse. Rather than telling the whole department, well, we've got a reduction in force, this, that, and the other, and we'll be letting people know today. Then you've got a stream of folks being saved. Will Mike Coffey please come to Bob's office? Oh, God, you know what's coming. So do it the opposite way. Hey, Mike, come on into the office. You do the deed, and then you have a meeting the next morning with everybody who's left saying, no, I guess you sort of figured out what was happening yesterday, and here's the situation for the rest of the day.
Yeah, that's and sometimes the dealing with the survivors is as difficult as dealing with the ones that you let go. The people that, sometimes they're the walking dead. They're stunned, and so you've got to get them back on message too, focused on this is where the organization is. And that's why I really like an organization that's really transparent with their financials and all. So here's where we are, here's where we hope to be, and we need everybody at 100% to get us there. And
right.
that's a short but really direct speech that I think a lot of companies just fail to give, and they let people just wonder what's next, and they worry, and next thing you know, the local Sam's is sold out of Tums because everybody's just agonizing about what's going to happen next.
That's absolutely right. And no matter what, though, when you get into that situation of telling the survivors, somebody will always ask, was that the only RIF we're going to have? You better watch it, because if you say, yes, that's the only one we're going to have, that's nice, but if you have another one, you have no credibility. There's nothing you will say to any of the survivors that they will believe. They'll never believe you again.
Exactly. Well, that was great, and amazingly, everybody stayed on the line. I appreciate everybody who joined us. This, Imperative does monthly webinars on, typically I'm, doing something related to the legal stuff related to background investigations and all the ways that employers are getting themselves in trouble there, helping them avoid that. But we had just so many oil and gas clients that I saw in the last, couple months having to go through this difficult process. I didn't, we're not involved typically on the tail end of the employee life cycle, but I thought this would, bringing Lon in would be really good for those folks and for the wider HR community. So thank you, Lon, for the time. We will be sharing this recording and the slides. Is that okay with you, Lon? I didn't even ask, but so let me ask you in front of your whole audience.
Sure, that's fine.
And so, and I figured it would be. So so everybody who registered will get an email with a link to all of that, and it'll be in a survey. So you give us a survey, give us feedback, which is something that both SHRM and HRCI require. And then after you've given us feedback, you'll be taken to the HRCI and SHRM recertification credit information. And again, I'm Mike Coffey with Imperative Information Group, and you've got Lon. Got us information there on the screen. If either of us can be of service to you, I'm sure we'd be thrilled to. And if you're in the North Texas area, stay warm and dry. Be safe. Thank you, Lon.
Okay, thank you for including me, Mike, and thank you all for out there for listening to me.
Bye-bye.
Bye now.